your right hand and your hand on the Bible. Do you affirm the testimony that you'll give in this trial shall be the truth, so help you God?
I do.
Take a seat in the stand. State your name again for the record. Spell your last name, please.
Afternoon, Your Honor. My name is Mark Tinsley, Tinsley.
Mr. Tinsley, how you doing today?
Good.
Introduce yourself to the jury a little bit. Please tell them a little bit about yourself, where you grew up, where you went to school, and a little bit about your profession, please.
Sure. I said my name's Mark Tinsley. I'm a lawyer. I practice in Allendale. I've been there since about 2000. I'm originally from...
Mr. Tinsley, get that mic a little bit closer to you.
Well, the mic's short, and my knees apparently are long because this is the most uncomfortable place to sit.
You can bend it down a little bit, maybe.
Yeah. I'm from Anderson originally. I went to Clemson. I carried an orange book bag when I was at Carolina. I went to law school there. I graduated in '98. I worked in Columbia for a couple of years doing primarily insurance defense work. You've heard a lot of plaintiffs' lawyers. So I would have been one of the lawyers representing an insurance company that was hired to or had the coverage on somebody who was getting sued, or I would have dealt with coverage. Is the specific loss covered or something? So that's primarily what I did for the first 2 years. One of my good friends was originally from Barnwell. I made my way to Allendale in 2000, and I've been there ever since.
And so since Barnwell, have you been in a law firm? You've been in practice? Tell us a little more about that.
I have. I practice with Gooding and Gooding. When you live in a small town, you do all kinds of things. I have the luxury of having a successful practice and being able to go to different places and handle cases. I try cases. I try truck wrecks. I try highway defect cases where there's something wrong with the way that the contractor had not really designed the road, but maintained the road, and somebody gets catastrophically injured. I tried bad faith cases where an insurance company has coverage, but for some reason or another, they don't do what they were supposed to do under the contract, and their insured gets harmed as a result or suffers a loss. And so, I pick and choose, but when you're in a small town, you help people. And so I end up doing all kinds of things. There's no case that's too small, no case that's too big. If I can help you, I try to help you.
All right. Over the years, being a lawyer doing this kind of work in this area, have you had call to get to know the lawyers and what used to be known as PMPED?
I have. There's only 17 miles basically between Allendale and Hampton, small bars. At one time, I think there were really only 4, maybe 5 lawyers in Allendale, and about twice, maybe it ultimately gets up to 3 or 4 times that many in Hampton, but it's a small bar. And I had occasion to work with, you saw Ronnie Crosby, I think, yesterday. I've handled a number of cases with Ronnie Crosby. You've heard Lee Cope's name mentioned. I've had cases with Lee Cope, but I knew everybody.
All right. And did that include the defendant, Alex Murdaugh?
It does.
And how long have you known him?
It's hard. I heard Chris Wilson this morning. I don't remember exactly. I came in 2000. I always remember him being there. So sometime shortly after I came to practice in the 14th Circuit.
And do you see him in the courtroom here today?
Sure. He's immediately to the right of Mr. Harpootlian.
Can the record reflect he's identified the defendant? Over the years, as you knew Alex Murdaugh, did you ever do anything professionally, either with him or against him?
I hate to be a lawyer, Mr. Waters. I have. I had a case where a defendant was in default, and Alec was a special referee, meaning you may remember Chris Wilson said in that Mack truck case, one of the defendants didn't answer, and so if you get sued and you don't respond at the right time, then you're in default, and so the other side by default wins generally. And Alec was my special referee, meaning this guy had been accused of selling some property under lien. He was arrested at his job, and we sued a company called Southern Finance that incidentally went into bankruptcy. It's a long, complicated story, but we got reversed, and so I didn't do that again. And
But
then,
just generally, have you had, go ahead.
well, yeah, I mean, but I didn't handle cases with Alec. I didn't, not unlike, say, Ronnie or Lee Cope, and we just didn't have that sort of relationship. You know, I guess he and I did so much of the same thing. I don't recall a time over the last 20 years where we worked on a case together.
Being a small bar and doing the same kind of thing, though, y'all are generally familiar with one another and the type of cases y'all were handling and that sort of thing?
Oh, absolutely. I mean, it's a small bar, and you go to the roster meetings. You know what everybody's doing. You see what cases they have. Yeah, absolutely. You know if they have a success, a big case, or a failure.
You ever been in court when Alec was doing a closing argument?
Yes, probably a couple of times. There was he tried a case in Allendale. It was the first case. I think it was '98 that the Allendale courthouse burned. The story is that Judge Peoples from Barnwell was going to sentence some guy for a drug offense, and Judge Peoples was very strict on drug offenses, and so the guys who were going to be sentenced on Monday decided Sunday would be a good day to burn the courthouse. So they burned the courthouse, and so many months later, I think Judge Peoples ended up sentencing them. At any rate, they rebuilt the courthouse, and so the first case that was tried in 2005, Alec tried, and I was there when he made his closing argument.
You were present when he did the closing on that?
I was.
Did he get emotional during that closing?
He cried.
Relevance.
Response. Your Honor, I think this is just relevant to the defendant and his practice as a lawyer, background information, and I think there's been a lot put in issue about the defense about that as well, and I think this is fair from this witness.
Yeah, we're in the year 2000.
2005, March of 2005, it was...
Same direction.
Let me ask you just a little bit about, though, being in this kind of type of work in a sort of small bar in a small area. You said y'all are generally familiar with what each other are doing to do similar work.
I think so.
And when you're, are there any sort of documentation at the court, jury rosters, anything like that, or rosters that you can pay attention to and have an idea of what each other's doing?
Well, I mean, it is a roster. It is a list of cases. Generally, a case comes up for trial, not in civil cases I'm talking about. Supposed to be about a year old. It's usually longer than that, but they go on this list. And so come Monday morning, all the lawyers would show up. There's 100 cases, and so you see what's coming up, who has what cases. And in Hampton in particular, Alec usually seemed like a majority of the cases on the Hampton roster. His name would be on them anyway.
And being a small bar and being, part of that, kind of doing the similar work, is it not uncommon for you to have some knowledge of some of those cases and for others to have knowledge of the cases you're working on?
Sure, lawyers are the biggest gossips in the world. I mean, everybody knew what everybody was doing.
If you see a case that's on there and then it gets removed or disappears, does that indicate anything to you?
No, I mean, it indicates they were settled, but oftentimes when you go through the roster, there's actually a notation. The case is settled. The judge will sign what's called a form order, which just administratively disposes of it, takes it off the roster so that it doesn't stay on that list.
And being as part of that small bar, and this is kind of work you do, that's something you generally pay attention to, as other lawyers part of that area do as well.
Well, it's a lot like sitting in here. I mean, it's easier to pay attention than to just sit there bored. So, yeah, you pay attention to it.
Are you familiar with what's been known as the boat case?
I am very familiar. I represent the Beach family, and so I filed the boat case.
And you say the Beach family, are you talking about the family of Mallory Beach?
The family of Mallory Beach, that's right.
And is she the young woman who died in the boat accident?
She did.
And what was the date of that accident?
It was the early morning hours of February 24th, 2019.
At some point, you said you were representing the Beach family. At some point, you were approached by the Beach family?
I was, shortly after the wreck. There was an incident on the causeway. So this boat crash happens. There's a bridge called, you go over Archer's Creek. Archer's Creek is it's a creek that separates Paris Island, the marine installation, from, I guess that's Port Royal. And the boat crash happened at that bridge. There's a road, if you can imagine the causeway, there's an old road that goes down to the base of the bridge. And after the boat crash, the law enforcement had cordoned off, had a rope up or yellow flag, yellow taping up, and so Miss Beach wanted to go down to see where her daughter had died, and she wasn't allowed to.
Objection. Relevance. Perjury.
Objection is overruled.
Please continue.
She wasn't allowed to go down to the bridge. She was told
not?
She was not. She was told it was a crime scene, and she couldn't go down there.
All right. What else did she, and when she was hiring you, what else did she report?
Almost immediately thereafter,
Hearsay.
For the truth of the matter, asserted the effect on the listener and the reasons for the actions he took, which has become relevant in the boat case.
You can only argue when requested by the court.
My apologies.
Objection is overruled.
almost immediately thereafter, a car pulled up driven by Alex's father. His wife was in the front seat. Alex's wife, Maggie, was in the front seat. They were waved down to the bridge, and that caused her a great amount of distress.
Did she ultimately hire you to represent her?
That day I got involved.
At some point, as you get involved, you start to investigate the occurrence?
I did. I started to investigate, but I started to try to put pressure on law enforcement, which is, I'm drawing a distinction there almost immediately, because the concern was that it was going to get covered up by the Beach family, and they didn't want that to happen.
Your Honor, I would object to these references to covering up. It's not relevant to the motive purpose for this testimony, and it is prejudicial under 403.
I sustain the objection.
And you strike the previous response.
Objection is sustained. You may proceed.
Yes, Your Honor. Just generally, you investigate the case, is that
I
correct?
did.
And at some point, did you reach out or have any discussions with anyone who was representing the defendant, Alex Murdaugh?
I did. Well, I've talked to a number of the partners, but after I
When you say
began,
partners, you're talking about PMP?
yes, I'm sorry.
All right.
But eventually I came to know that Danny Henderson was appointed as Alex's personal counsel, who was one of the partners. You may remember there was a video from Alec in the front seat of the law enforcement car, and the arm that reaches up and squeezes his shoulder while he's crying. That's Danny Henderson.
All right. And did you and Danny Henderson, did he have any documents for you to review?
He brought me all of the insurance policies for all of the insurance that Alec had in place at the time of the boat crash.
And for what reason did he bring you those documents?
Well, when you do what I do, we can't turn back the hands. We can't undo what's happened. And so, the best that you can hope, and when you get a case like this, this kind of loss, nobody gets what their case is worth, if that means anything. I mean, nobody would willingly trade place with these people for money. But that's all that you can do in a civil case is recover money. And so some things are covered by insurance, some things are not. And so many times when we are drafting lawsuits, we want to know what insurance there was so that we try not to destroy the ability for the insurance to apply in the beginning. So that would have been the reason I was looking at the insurance.
His attorney, Danny Henderson, brought the defendant's policies to you to review, is that right?
It seems like it was a week, 10 days after the boat crash.
All right, and did you review those?
I did.
And what, if anything, did you find in those documents?
It did not appear to me that he had any coverage other than there was a policy with Progressive, a watercraft policy that applied to the boat. It was $500,000, and it was offered by Progressive immediately. When you have a catastrophic loss, it's not unusual that an insurance company will say, here's our money, take it, please, because they have an obligation to protect their insured if they can. The other policies that he had didn't provide coverage except for a for-hire hunting operation, which this didn't arise out of. And so,
What company was that with?
Philadelphia Insurance.
All right, and again, that policy was limited to what?
The occurrence, the accident, if you will, had to arise out of a hunting operation, a business operation. And even if there was some way to say that this boat ride this night did that, there were very specific watercraft exclusions that then excluded the coverage. So accidents are covered, but then you have all these exclusions that take the coverage away. And so there was no coverage.
Did the defendant have an umbrella policy? First, tell the jury what an umbrella policy is very quickly, if you could.
An umbrella policy would be if you have a primary policy, say on your car, the umbrella policy would sort of be a coverage. It could be broader than your car. It could also apply to your house. Generally, that coverage is, the limits are multiples of maybe what your liability limits are, and it could be broader than just your house. It could apply to your house and your car. So I don't remember. I think all of the coverage was with Philadelphia, and I remember reviewing all the policies. I don't remember if it was exactly what they were referred to this time.
Did you ever find out if the defendant had an umbrella policy or the status of that policy?
There was no coverage for this boat crash other than with Progressive on the boat.
Did the defendant have an umbrella policy at one time, to your review?
He had coverage. He had the coverage with Lloyd's of London and Nautilus immediately before, which was the coverage that was in effect when Gloria Satterfield fell at his house. And he had an umbrella policy there.
All right. And what happened to that policy, that coverage?
The policy came up for renewal. Normally they're a year. It comes up for renewal, and this claim's still open. And so when it came up for renewal, the insurance company wouldn't renew the policy, and they canceled it, which is why he then went and bought this hunting club operation or hunting for hire operation, whatever that policy was, but didn't really cover anything because he didn't have that kind of business.
In your assessment and judgment, would that Philadelphia Hunting Lodge policy provide any coverage for the boating owner?
It did not. I told Danny Henderson in November of 2019 that it did not. Philadelphia filed something called a declaratory judgment action, where they go and ask the court to declare their rights, meaning we don't have any coverage. It's clear the policy doesn't apply. Judge, tell, in this case, the plaintiff, because they sued us, the Beach family, and they sued Alex Murdaugh and for a declaration there was no coverage. I refused to participate. I said I would just be bound by whatever the result was because I knew what the result was going to be.
Generally, at this point in time, what was your assessment of the defendant, how lucrative the defendant's practice was and his general wealth?
Well, so I believe that he was making lots of money. I told you that he had most of the cases. So if that's 50% or 60% of the cases that are actively resolving, he's actively making money. Money's coming in. Now, whether I knew that how the law firm worked in terms of they would get their money at the end of the year, that's not uncommon, but it doesn't really change the boat crash. So by the last 3 to 5 years.
And ultimately, with your review of the insurance coverages, the only one that you thought was applicable was which one?
The Progressive boat policy.
And how much was that?
$500,000.
And from your assessment of the case, was that going to be enough?
No, it wasn't. There were 6 people on the boat, including Alex's son, Paul. So there was one girl whose hand was pretty severely injured. She had about $130,000 in medical bills, a couple of surgeries. You had one boy who was thrown into the console and had a broken jaw.
Object to this 401, 403.
And opinion.
Objection is overruled.
And his medical bills exceeded $100,000. So, you got a death, you've got 2 people with substantial medical bills, and there was just no way there was enough coverage at $500.
As a result of that assessment and your assessment of the defendant's lucrative practice and wealth, what, if any, goals did you develop for this particular litigation?
I don't know if it's as easy to answer that, but as I began to realize there was no coverage, it was clear that and oftentimes when you have someone who is very affluent, who has a lot of money, it's not uncommon for those people to pay in addition to what they have in insurance. And so Alec was going to have to pay out of his own pocket to settle the cases.
Did you ultimately file suit in this matter?
I filed suit, I think, about a month after the boat crash. I filed suit before the criminal charges were brought.
Criminal charges against who?
Paul, I'm sorry.
And so in March of 2019, you filed suit?
I believe so.
And did you sue the defendant?
I did.
Without getting into the weeds too much, what's the basis of potential liability for the defendant?
So, in the very beginning, if there was any chance at coverage, the allegations were that he knew that his son Buster, his older son Buster, who was 21 years old, had obtained a duplicate license, and that Paul was using that license to buy alcohol. And so it's sort of Alex lawyers from time to time have characterized it as negligent parenting, but it's in the law you have this idea that there's this thing called negligent entrustment. You know that somebody drinks, you know that he has a propensity to drink in excess, get drunk. You give him your vehicle, you've created a hazardous situation, and so that's the liability against Alec. And so what I did in the very beginning, in the first lawsuit, was I drafted it to try to see if there could be coverage, even though I didn't think it was going to be successful.
You testified that you'd made the assessment that the defendant was going to have to personally pay in this matter, correct?
He was.
Did you ultimately communicate that to his attorneys and to the defense in this case?
Multiple times and very clearly.
And in this case, I mean the boat case.
Yes.
Is there such a concept as a friendly defendant or a venue defendant or a placeholder defendant in civil litigation?
There is.
Can you just very quickly explain that to the jury?
It started, you first see the references back in, I think it was the 40s and 50s, and it was a way that if you're from out of state and you get sued in South Carolina, you have a right, rather than be in state court like we are now, you could have it, that case against you taken to federal court. And so oftentimes what people would do to keep the out-of-state person from taking it to federal court and rather keep it in the county where they knew everybody is you would also sue someone in state. And so it was a venue defendant. Now, and that kept the federal court from having what's called diversity. But in civil cases in state court, sometimes you do that. I mean, if there are two people driving a car, driving two cars, two people involved in the wreck, the passenger didn't cause the wreck. So you could sue both and let the jury sort out who it was, even though you believe that probably 99% of the liabilities on one person, or maybe all of it's on one person. Juries do crazy things sometimes.
Had you made it clear to the defense during this time that you were not considering the defendant just a friendly defendant or a placeholder defendant or a venue defendant?
From the beginning and very clearly.
And that meant you were seeking a personal recovery against him?
He was always going to have to pay and pay a lot of money.
Does your area of the law, do y'all have some sort of annual conference every year that many people involved in it attend?
We do. Michael Gunn mentioned it. I think he called it SCADS or SCAD. I don't know. So I called it the Trial Lawyers Conference. It was at the Westin at Hilton Head every year.
And what time of year what month does that take place?
It's usually the first weekend of August. So that if that's first, second, third, or fourth, fifth, and sixth, but it's usually that first week of August.
In August of 2019, did you attend that conference?
I did.
And did you see the defendant there?
I did.
And did you have any conversation with him?
Normally, different law firms have dinners and groups of lawyers, because it's marketing too, right? I mean, you go and you have dinners and you take other lawyers out who may send you cases or get you involved in cases. And so after dinner, everybody sort of comes back to the hotel, and there at the Westin, there's a gathering area. And I think it was a fundraiser, either for Mr. Harpootlian or for Lindsey Graham. But there was a whole room of lawyers, and he saw me. And this is the first sort of gathering. There's a little tension, I think, generally in the room about it. And then he beelines across the room and gets about this close.
And what does the defendant say to you?
Hey, Bo, what's this I've been hearing about what you've been saying? I thought we were friends.
And did you respond to that?
I did. I told him that we were friends, that if he didn't think that I was going to do everything I needed to do to help my clients, he was wrong and he needed to settle the case.
Was that conversation about your intent to seek a personal recovery?
That's when he said, what's this about what I've been hearing? I thought we were friends. That's what he was talking about. He didn't like the fact that I was saying he was going to have to come out of his pocket and pay.
Moving on to the following month, was there a mediation in the case?
The next year. So that was
2020.
August of 19. We don't have the mediation until September of 20.
At this point in time, the case has been filed, and without getting into detail, you're generally engaging in the discovery process. Is that correct?
We are, which is you go and you put witnesses under oath, and you take their depositions and you examine them and you collect documents and those sorts of things. But we were taking depositions, primarily of law enforcement, the people at the emergency room, that sort of thing.
What happened in March of 2020 that affected everybody?
Well, COVID began to shut the courts down. We continued to take some depositions, but ultimately, I think it was probably April, May, then we were sort of confined to our offices by then. So in March, we're still taking depositions of law enforcement, and it sort of slows down.
You continue to work on the boat case?
We did.
Continue to gather evidence and documentation?
I did. One of, there was a number of things that we knew existed that had not been collected by law enforcement and didn't appear to exist as far as law enforcement were concerned. And so, for instance, I subpoenaed from the Department of Defense, I believe, and ultimately got all of the federal government's documents of affidavits and things of witnesses that were out there from Parris Island.
And without getting into all the details of the evidence, were you gathering evidence that you felt make your claim against the defendant strong?
It did.
And did you share some of these at least some of these findings with the defense?
Well, they're sitting in the room. I mean, they might not know it until I bring it out. The first lawyer asks questions, and then the person may or may not be completely truthful, and then you bring out the document. And so they're seeing it happen. And that's mainly with law enforcement. There were a number of law enforcement depositions where that happened.
As you're moving through the months of COVID and their shutdown and everything like that, is one of the things that you do is use a mock jury to sort of assess your case.
Or 143.
Objection's overruled.
I did in this case.
All right. And some of this evidence that you felt was strong, did you sort of present that to this mock jury? It is just as a tool to help you assess how strong your case is and how likely it is of a recovery.
Yes, and I was specifically interested in Beaufort County, and I can explain that if you want.
Just very briefly. I was trying not to get into the weeds too much, but just yeah, if you can.
So the alcohol was sold by a convenience store, Parker's convenience store, and the Parker's lawyer at times would seem to act like Paul wasn't the driver, and at other times.
The objection's overruled.
At other times, he would go after law enforcement specifically about that particular officer's connection with Alex Murdaugh or the Murdaughs in general. And so you really can't have it both ways, right? I mean, if Paul's not the driver, you don't really worry about the alcohol that was sold, then the connection with law enforcement sort of becomes irrelevant. So and it was clear what they were doing was they were trying to try a case that look at all the bad things, don't let him get away with this because of verdict against Parker's. And so I was interested in if we went to Beaufort, because I'm being told by Alex's lawyer that a Hampton jury won't return a verdict against him. And so what I'm trying to determine is if we go to Beaufort, is the evidence that I have uncovered so overwhelming that a jury ignores the clear breaches by Parker's company?
And ultimately, again, without getting into the weeds, were the results of that exercise with the mock jury, did that give you further confidence in the strength of a large recovery against the defendant? Just answer
Yeah,
that.
absolutely.
And ultimately, did you communicate that to the defendant's defense team?
I did. I also, to Ronnie Crosby, who said that he would talk to Alec, and then they wanted copies of some of the statements by the people that wanted to take everything he had.
What time period are we talking about right
This
here?
was May of 20.
Did you have anything else going on in your life as this time period was going as well?
Well, I was getting divorced.
Okay. That's significant.
Yeah. But yeah, so, all right. But, yeah, I think you're later in the summer, but.
I got you. As we move from May of 2020 into the fall of 2020, are those conversations continuing with the defense about the strength of your case and your desire to have a personal recovery against the defendant?
Sure, there was a lot of pushback about the shock that I would hold Alec personally responsible, make him pay. And then in August of 20, I figured out that I had cancer, and but we continued to work, and then probably by November, I knew how bad it was, and I knew that I was going to be gone, and so I tried to make arrangements to do things because I'm still having to decide. The case is getting some age on it. We filed it pretty soon. A case that gets about a year old ought to go on the trial roster. We have mandatory mediation. We're going to mediate it in September, and then immediately after that, it would be eligible for trial. We didn't settle the case, and in November, I sent some requests to admit, which is in the law, in civil cases, there's all this evidence. It's like in here, you've seen this. You have to bring somebody in here that says, I opened the car door, and then you bring the next guy in and says, well, I took the mats out. And if that's not disputed, then we can send something, it's a written question, say, admit that it was daylight when this happened. Okay, we'll admit that. So we don't have to call somebody in. And so it's admit certain facts to be true, and then those things are taken as true, and we don't have to presume them. So I had made up my mind that I was going to send the case to Beaufort after the focus groups, and I was going to try the case in Beaufort. So I sent requests to admit in November of 19 before I was about to leave to go to Florida for my cancer treatment.
In November of 19?
I'm sorry, November of 20. I think it was November the 19th. But
All right, before we go there, you've had some discussions with the defense about the strength of your case, as you've talked about, correct?
oh yeah,
And the strength of your case against the defendant, is that correct?
yeah, and one of
Just
the
real quick,
other.
let me ask a question if you could.
Sure.
Had you had any discussions about a number that you were seeking from the defendant, roughly?
I ultimately I have that conversation. They pushed me for a number. By November, I've given them a number. Yes.
All right. And roughly what that number was?
That number, he was going to have to pay $10 million out of his pocket.
And did the defense have any response to you eventually?
That he could cobble together $1 million. But
Did
he
they have
was
any
broke.
other response?
He was broke.
He was broke. He can only get $1 million.
Maybe could get $1 million.
Based on your knowledge of the defendant and his practice as you've testified, did you accept that response that he was, quote, broke, end quote?
No, I didn't believe it at all.
Did you offer him any other sort of settlement, any sort of type of plan or anything like that?
If you're broke, I'm happy to work out a payment plan. You can make payments. You can convey Moselle. I knew he had Moselle. He got Moselle right after a big settlement in 2012. So that's 1,700 acres. Conveyed Moselle, convey the beach house. He still had the house in Hampton. And we'll work out a payment plan on the rest.
Did they reject that?
He did.
Having been told that the defendant is broke despite what you believe, did you have a response to them?
I did. In October, almost immediately after the mediation, I served some discovery. Again, it's a written question, and there are two different types. There's interrogatories where you ask a question, tell me where you bank. And then there could be requests for production, give me your bank records. Now, I didn't say that, but I did. I sent discovery
And
to...
just real quick, we'll talk about discovery in a second, but generally, what is that response? He says, I'm broke. What are you saying in response?
There's no way. I mean, like I said, he has a spigot of money that's running. He's settling cases. He's got big cases. He's got lots of cases. He's got generational wealth. There's no way he's got 1,800 acres in Moselle. He's not broke by anybody's standards.
Did you ask the defense to, okay, show me the books, prove to me that you're broke?
I did.
And what was the response?
No.
So that led you to some discovery?
It led me to send discovery to get that information.
And specifically, what information as it relates to the defendant's books and the defendant's accounts are you talking about?
Well, it was broad, so it was broader than this, but what I was looking for was the institutions, the accounts where he did his banking. Because if he was, in fact, broke, if his bank account says $0 or $5,000 or $7,000, it was because he was hiding it, in my opinion, at the time. So that's what I was looking for.
And so you sent those discovery requests?
I did.
And did the defendant provide that information, or did they decline to provide that information?
They objected almost immediately.
And so did you then file some subsequent legal papers because they refused to provide the information about the defendant's accounts?
I did. I filed what's called a motion to compel, where I asked the judge to compel or make him give me the information.
I'm going to show you what's been marked as State's Exhibit 402, and just generally just see if you recognize this document. If you flip through it real quick.
I do. It's the motion to compel that I filed with three exhibits, which are his lawyer's responses, the objections to the questions.
All right. What's the date on that document? The motion to compel.
The motion to compel was filed October the 16th, 2020.
Your Honor, this time I would offer State's Exhibit 402 in evidence, I believe, subject only to a previous objection.
No additional objections, Your Honor.
It's admitted.
Can I have the screen over there, please? All right, this is State's 402, the one you just described, is that right?
That's right.
And that's the date on it right there?
Correct.
And I've turned over what's Exhibit B to this document. And is this some of that discovery asking for the defendant to identify his specific bank accounts that you were just describing?
That's right.
And can you just read number one right there? That's a question that you're asking the defendant to provide to you, correct?
Yeah, what you see there is the bold, the answer is, so this is, Alex's lawyer has retyped the questions that I sent. So that's the question that I wrote. Number one, list all checking and or savings accounts, including credit union accounts, certificates of deposit, 401k accounts, SEP accounts, IRAs maintained by you individually and or jointly with any others, and any other accounts over which you had signature authority for maybe it's in any capacity, regardless of whether or not the account or accounts have been closed from February 2019 to present. And then the answer is what his lawyer said, which is generally an objection that's overbroad, it's unduly burdensome, it's not relevant, doesn't have anything to do with it. So
they had objected, and you filed a motion to compel. And again, without too much detail, is a motion to compel to ask the judge in the civil case to force them to provide you this information.
that's right.
And if that had motion, and we'll talk more about this in a minute, but if a motion to compel is successful and you had gotten the defendant to produce the identity of all accounts he had, what would have been your next step if you continued to follow that thread?
Well, so I knew some information. I would have verified that he was telling me the truth, right? So some things I'm verifying, but I would have ultimately sent subpoenas to the banks, and then I would have begun to subpoena the accounts. I mean, I know he's got a personal account. I know that the law firm's got accounts, but he's got these other entities, these partnerships and things. I didn't know if he had accounts there. So that would have been what would have happened next.
At this point in time, were you aware of any institutions that you believe the defendant had bank accounts at?
I knew about Palmetto State Bank, and I believe that I knew about Bank of America.
At this point in time, though, did you have any idea about all the stuff over there with the fake forge account and all this other stuff that the jury's heard about?
Not a clue.
But had you been successful, you would have sought to identify all accounts in his name and then reviewed those accounts. Is that correct?
Yeah, the subpoena to Bank of America wouldn't have said, give me the information for account 102 or whatever the number was. It would have been for all accounts that have his name on it, period, in any capacity. So it would have been very broad.
And to be fair, they could continue to object to subpoenas and that sort of thing, but this was, if you had to follow this thread, that was the tack that you were taking by filing this document. Is that correct?
That's exactly what it was, and I was doing it like you heard Chris Wilson talk about in that Mack truck case, that the defendant didn't want this to happen. Well, this is normal in a civil case. There's lots of times that defendants don't want certain things to happen, and so if they don't want it, that's what I want. So I'm putting pressure where I can put pressure, and this is a place that I can put pressure. At the time, I think it's because he's making so much money, he doesn't really want us to know how much money he's making.
That motion's filed in October of 2020. Is there any hearing on that scheduled right away, or does that take sometimes a while for that kind of thing to happen?
It took a while. COVID wasn't over, but the courts weren't really running. There were some courts, when the Chief Justice began to open the court system back up, they had to have some kind of COVID plan in place. Hampton wasn't one of them. This case had been specially assigned to a judge from Lancaster, and so there weren't any real opportunities to get the motion heard at that time.
You had initially described how you were, initially, what county did you file this lawsuit in?
I first filed the lawsuit in its first draft in Beaufort County.
Okay. And as we're moving to this time period, COVID slowed things around, you filed your motion to compel. Are you considering moving that to a different county?
By November, I've pretty well made up my mind that I'm going to move it back to Beaufort County. And it's not just that I'm moving it back, it's that Parker's also had a motion, so I could consent to its motion to move the case back.
And so you're considering putting it in Beaufort at this point, is that right?
That's right.
And was that in part because the defense or the defendant over there believed that didn't get a verdict against him in Hampton County?
He was insistent.
As we move into early 2021, again, I don't want to get in for purposes of this trial for the specific discussion as it relates to other defendants, but had you start to reassess the decision to maybe take it to Beaufort County?
Yes. While I was in Florida, beginning in January, Mr. Parker, who owned Parker's Convenience Store, began to do a number of things that I thought would weigh against me going to Beaufort County.
Yeah. And so did you communicate perhaps moving it or keeping it in Hampton County or moving it to Hampton County?
Not until I got back from my treatment in mid-April.
All right. Stand by for me real quick. Let me ask you this. You said you'd start considering moving it back to Hampton County because of some things that was happening with another defendant, that being the convenience store in Beaufort County, correct?
You said Hampton. I think you meant Beaufort.
Sorry. Let me rephrase that. You're in Beaufort at this point, correct?
No, I'm in Hampton. I filed it initially against Luther's, which was a bar after. So the kids launched a boat from Alex family place to Chest, and it's owned by Family Trust, Murdaugh Family Trust. Maybe there are two properties and there's two trusts. So I sued Alex's father. I sued the trust because could have been that alcohol was provided there. It turned out it wasn't. But the kids drank and launched the boat from there. And then they went to an oyster roast. I sued the people who had the oyster roast. From there, they went to a bar called Luther's where Paul had 2 shots. And so I sued Luther's and I sued Alec. And I'm not 100% certain in that first lawsuit whether I sued Buster or not. But I ultimately did sue Buster.
You were describing you were in April 2021. Had you at that point had some thought process that you communicated to the defense about having the case in Hampton?
Yes, I did.
Okay. And was it because of some of those things with that other defendant that you had mentioned?
So
Without getting into the
it was. And the motions were coming up. I mean, it was, I've been gone for 4 months or whatever it is, 4.5 months. And so the motions are set to be heard. And there are a number of motions. Parker's, I said, had filed this motion to transfer the case to Beaufort before I left.
As you're thinking about, as we're in April of 2021 and you're thinking about putting it in Hampton, you were still concerned, though, about a case against the defendant in Hampton County, his home county, correct?
I think you're still getting Beaufort and Hampton mixed up, but so not exactly. I was.
All right, well, you explain
Okay,
to me.
I'll explain. There were a number of reasons that I wanted the case in Beaufort. I had substantial evidence. One of the things that we didn't talk about was when you have a 17, 18, 19-year-old girl, which I have, she constantly has her phone and she's constantly taking videos. And so one of the things that I discovered is that Paul's girlfriend had tons of videos. Videos of alcohol and family trips, videos of Paul drinking in front of his parents, videos of him grossly intoxicated. And so that evidence I shared with Alex lawyers as well leading up to it. I didn't share it. They didn't serve the same discovery on me because they didn't want the other defendant, Greg Parker's, to have it at that time because they were so entrenched in that there was some sort of venue-friendly lawsuit going on between Alec and myself, but there wasn't.
Okay. As you're considering all these issues, did you ever convey to the defense any issue about suing any other defendants in Beaufort County if you felt like your case was not getting a fair shake in Hampton County?
So once I made the decision,
Ladies and gentlemen, we're going to stop for the day. We're going to resume at 9:30 tomorrow morning. Please not discuss the case. Thank you. Good morning. All right, ladies and gentlemen, welcome back. Day number 15, state's case. The last objection was sustained, and ladies and gentlemen, I want to remind you when I sustain an objection, that means you're to disregard the question and any response. You may proceed.
Yes, sir, Your Honor. May it please the court. Mr. Tinsley, good morning.
good morning.
Just to kind of reset the table from where we left off, you had testified about pursuing the case against the defendant over the boat wreck, correct?
Correct.
And you had communicated to the defense that the defendant was going to have to pay personally, correct?
Correct.
Not just the insurance,
Correct.
And you had been told that the defendant was broke, correct?
That's correct.
And you had filed a motion to compel. Had you filed a motion to compel, States 402, seeking to identify any bank accounts that he had?
In October of 2020.
Could I have the element, please? And the screen. David, if you can help. All right. I think one of the things that you had also testified to is that just generally COVID had kind of slowed things down in the court system.
Ultimately, yes.
And then you had some health issues that you were dealing with as well. Is that correct?
At some point, yes.
At some point in time, did a hearing in the boat case that would include a hearing on this motion to compel that's on the screen get scheduled?
It did.
And when did it initially get scheduled?
My recollection is it was set for May the 30th, 2021.
All right, and let me show you an exhibit real quick. I'm going to show you what's been marked as States 404 and see if you recognize this document.
I do.
All right, and what is that?
That is a communication about the hearing. It's actually about a status conference about the hearing that's going to be on May the 30th.
Okay. All right, and what was the day of that status conference going to be?
May the 7th, 2021.
All right, and then look at the subject line on that and just take a look at that real quick.
Motions hearing May the 11th.
Yeah. Was that the date or was it May 30th for the motions hearing? To your recollection?
To my recollection, it's May the 30th.
All right. But this email is related to that particular hearing, is that correct?
It's related to the hearing on my motion to compel and some other hearings, yes.
All right. At this point, Your Honor, I move to admit States 404, I believe, without additional objection.
No additional objection.
And is that the particular email we were just discussing?
It is. And you're correct, the hearing was May the 11th.
May the 11th?
Yeah,
Okay. Haven't seen that. That refreshes your recollection?
yes.
We'll show you now what's been marked as States 405. And have a take a look at that and see if you recognize this.
I do.
All right, and tell me what this is, please.
It's an email from Judge Hall, who had been assigned the case about the hearing. John Tiller, who was Alex's lawyer in the boat crash case, was diagnosed with pancreatic cancer about the same time, just before I found out I had cancer. And so he had a chemotherapy treatment that was going to run long the day of the hearing. He didn't always know when his treatments would be, but about a week before he would know. And so the hearing needed to be rescheduled to accommodate John's treatment.
All right, and just initially, when that request was made, what was the judge in that case's response?
The hearing would go forward as scheduled, and one of Alex's other lawyers could attend.
All right, so initially the judge denied that continuous request, is that correct?
That's correct.
And what happened after that that ultimately resulted in it being continued?
I sent an email. John Tiller was my friend, and I didn't object to continuing it. And then the judge had a status conference, and at that point, we continued the hearing until June the 10th.
In the course of this litigation, given that we were coming out of COVID, had the judge in that particular case been relatively aggressive in wanting to move this case forward, to your assessment?
The judge knew that I was in Florida receiving treatment and was accommodating that. No, he wasn't being aggressive at that time. It was when I was ready, and so I was back and we were ready.
And that's what led to this initial hearing, is that correct?
Correct.
But ultimately you agreed to let this thing be continued, correct?
I did.
All right. Your Honor, this time I'd offer State 4 or 5 into evidence.
No additional objection.
Submit it.
And down at the bottom of this email chain, what's the date on that? Can you read there on your screen, or I need to bring it back to you?
May 5th, 2021.
And that's communication from whom?
That's from John Tiller to Judge Hall.
All right.
And that's relaying the need for the postponement for the chemotherapy treatment.
All right. And then there were the communications from you related to that, is that correct? Well, let me go right here. This is the response right there, is that correct, from Judge Hall?
That's the initial response, that he intended to go forward with the hearing as scheduled, and that Mr. Condon from the same firm could handle it.
Show you now what's been marked as State 406 and see if you recognize this particular document.
I do.
All right. And what is this? Tell the jury what this is, please.
That's an email from John Tiller. So after the email that's on the screen saying I intend to go forward, John Tiller sent another email explaining a little more detail what was going on, and that he had, I believe it says he had spoken to me and I had agreed. They were my motions. There were some other motions, but when it's your motion, you can agree to continue it if a party wants it continued and you don't object. And so that's what that's doing, is trying to get the judge to not go forward with the May the 11th date.
All right, Your Honor, this time I'd offer States 406 in evidence.
No additional objection.
Submit it.
All right, and the date on that particular email is?
May the 6th, 2021.
Did the judge ultimately, though, based on this series of emails, granted the continuance on this motions hearing, correct?
Well, he gave us a status conference in which we did by video, and ultimately he agreed.
Okay. And what day was the motions hearing that included the motion to compel rescheduled for?
June 10th, 2021.
Going back to States 402, one of the matters that was on the table to be heard would have been your attempt to get compelled responses to this interrogatory from the defendant, correct?
That's correct.
Seeking identification of his bank accounts.
That's correct.
Remember what day of the week? June the 10th, 2021 would have been?
I believe it's a Thursday.
How'd you hear about the murder of Maggie and Paul?
I got a phone call sometime in the middle of the night, 11:30, after my recollection.
That was on June 7th, 2021,
That's right.
into June 8th, 2021?
I think I heard it's still June 7th when I hear about it, but yeah.
On June 8th, 2021, did you have any conversations with any of the lawyers involved in the boat case or any communications?
I believe so. I think that it was more of, there wasn't a whole lot of consideration to be given to the fact that the hearing wasn't going to go forward. It was sort of shock and horror of what had happened, and nobody really knew what to do in the moment.
Of course, that hearing's not going forward after this,
It
correct?
did not.
We'll show you what's been marked as States 407 and see if you recognize that particular document.
I do. This is an email from Judge Hall's law clerk, Judge Hall's over the boat crash case, to me and the lawyer for Parker's, as well as about the fact that the hearing's not going forward.
All right, this time I'd offer States 407.
There's no objection.
So admitted.
What's the date of that email?
June 8th, 2021,
What time?
4:24 p.m. I think there's an email from John Tiller that precedes this one that morning, but
Right. But ultimately, there were communications the following day that obviously we're not going forward with this hearing on the motion to compel, correct?
yeah, pretty much immediately.
And at that period of time, was there any date set in the wake of all of this for it to be reheard?
There was not.
In the wake of the murders, did you generally understand or have an idea of at least what had happened to Maggie and Paul, how they had been killed?
I did.
Just from media reports and the rest of it?
That's right.
And did that have any effect, that tragedy of their deaths, did that have any effect on your assessment of the boat case and how everything fit together if things were how they initially appeared?
It would have affected. I mean, yes, it did, and it would have ended the case
It would have ended the case against who?
against Alex Murdaugh.
And explain that to the jury. Why? What had changed after this terrible tragedy?
Well, when you have a civil case, nice people get good verdicts. Okay, just generally speaking. Yes, sir. Nice people get good verdicts. You really have to motivate a jury to want to help somebody in a civil case. And so if you compared, say, Attila the Hun with some sweet grandmother, who gets a better result? It's the sweet grandmother. If Alec is the victim of a vigilante, nobody's going to hold him accountable. Doesn't make any difference what he did or how clearly what he did contributed. The case would be over against Alec. And so initially, it could have been over. It appeared that it was going to be over against Alec because I had other defendants. I had Parker's convenience store that clearly violated its rules, and so you wouldn't want a very sympathetic person in your case when you have somebody who clearly violated the rules and caused this tragedy. So it would have been over against him.
The sympathies of the case had changed if Alec had truly been, his family had been the victim of some vigilante or something like that.
The sympathies would have changed if that had been true.
And assessing those sympathies and those emotions in a case like this is what you do as a plaintiff's lawyer, is that correct?
It's what we try to do.
And it's what Alex Murdaugh used to do as well when he was a plaintiff's lawyer.
I think he was good at reading people and knowing what made them tick.
Thank you, Mr. Tinsley. Nothing further at this time. Please answer any questions the defense may have.
Thank you.
Mr. Barber.
Good morning, Mr. Tinsley.
Good morning.
Let's maybe just start asking a couple of questions that I think are just some things that we could agree on. before maybe getting to some other things. Was there any life insurance for Maggie or Paul?
I don't believe there was any life insurance on anybody, including Alec.
And if this motions hearing, which was not just the motion to compel, it was other motions, correct, on June the 10th?
Yeah, there were some other motions.
And if that hearing had gone forward, at least for the motion to compel, this would have been another step in a process, right? In other words, I believe it was your previous testimony. I think it's fair to say that there wouldn't have been an explosion on June the 10th. That this would have been another step, but it wasn't the end point.
So what happens?
Is that correct, sir? Yes or no? Am I misstating your testimony? There wouldn't have been an explosion on June the 10th?
You're jumping around, so it's hard for me to follow.
I apologize.
Well, if you let me finish.
No,
Your Honor, I would like to ask the witness to be allowed to finish his answer to one of those questions, and I object to the form of the question.
Pose one question.
Yes, Your Honor. Did you previously testify, I think that it's fair to say there wouldn't have been an explosion on June the 10th?
I'm sorry,
Yes
you
or
were
no?
looking down. I couldn't hear what you said.
I'm sorry, I was reading it. I think it's fair to say that there wouldn't have been an explosion on June the 10th. Did you testify, did those words come from that stand when you previously testified, yes or no?
I'm not trying to give you a hard time. You looked down again, and I could not understand what you said.
I
Was there an explosion?
apologize for that. I'll hold it up. I'm just trying to read it accurately. I think it's fair to say that there wouldn't have been an explosion on June the 10th. Yes or no, is that your testimony previously? Just yes or no.
It's possible. You're trying to turn it into something it's not, but I probably said words to that effect.
Okay. No further questions, Your Honor.
Any redirect?
You're asked about the motion to compel being another step in the process. Is that correct?
It was a way to put pressure on Alec.
But if, after that hearing happened, and an order granting a motion to compel had been issued, that starts a process that's going to run its course. Is that correct?
Objection, pleading.
If a order is, I'm sorry, I'll rephrase that. If a order to compel is granted, tell us about the process that happens after that as it relates to your specific interrogatory we've talked about here today.
Sure. The process starts on Alec's side way before. If you look at those exhibits that they marked the email, you'll see Danny Henderson. Again, Danny Henderson was his personal lawyer. Danny Henderson is also a shareholder in the firm. Danny Henderson is reviewing every single document. That's how meticulous Danny Henderson is. He reviews all of the account information before I get it. And nobody knows better what Alec's making than Danny Henderson. I mean, you'll see all these checks going out and all these payments being made, and Danny Henderson would have known. So the explosion.
Object, Your Honor. Objection.
Basis for the objection.
Foundation.
Response.
Your Honor, he is speaking of,
Speaking of response to the objection.
he has testified as to the fact of his interactions with that individual who actually brought him insurance documents to review. I think he has a basis to know.
Foundation and your response to the objection.
I believe he has sufficient foundation to address that from his personal knowledge, Your Honor.
Overrule the objection. You may answer.
Thank you, Your Honor. For instance, I had subpoenaed the phone records, not only Alec's, his father's, but we also had John Marvin, Alec's brother's phone records. Danny reviewed those records for a long time before I could get my hands on them. Danny was involved in everything. He was at every hearing. He was at every deposition. He was intimately involved in every aspect of the case.
If an order to compel is issued, what was going to be your next step if you had an identification of accounts by the defendant?
Subpoena those accounts.
And if those accounts are subpoenaed, can potentially people move to quash those?
They could move to quash, but Danny Henderson would have looked at the documents in anticipation that I could get them.
Speculation.
I sustain the objection.
If motions to quash had been filed, though, you could have continued to seek that and there would have been further hearings. Is that correct?
I would have continued.
Objection to sustain, that's the leading.
What would have happened if motions to quash were filed as to any subpoenas you issued to it for the specific information about the defendant's accounts?
I would have continued to push. We would have continued to argue about it.
Would have a process been put in motion, though, that was going to conclusion if an order had been issued on June 10th, 2021?
Absolutely.
Thank you. Nothing further.
Anything further?
No, Your Honor.
Step down.
Thank you.
The next witness.
May it please the court. Your Honor, this time the state of South Carolina calls Ms. Blanca Simpson.